All rise.
Justice of the Caribbean Court of Justice.
Please take your seats. Caribbean Court of Justice Appellate Jurisdiction on appeal from the Court of Appeal of Guyana. CCJ Appeal number 7 of 2018 between the Guyana National Co-operative Bank versus R.N. Persaud Company Ltd, Leguan Rice Milling Incorporated, and the Registrar of Deeds for the hearing of the appeal this morning. Can we have the appearances for the court, please? Thank you.
Good morning.
Good morning, Your Honours. Sanjeev Dattadin for the first and second name respondents.
Okay.
If it pleases Your Honours, appearing in association with Mrs. Deborah Kumar Chitty for the third name respondent, the Registrar of Deeds.
Right, thank you. Well, good to see you, Mr. Jonas, Mr. Dattadin, again before the court. One point that struck the court reading the papers and reading the submissions of Mr. Dattadin on behalf of the first and second respondents is whether we can reduce some of the matters before the court today. In particular, we note that in the appeal from the High Court to the full court, there was an express reference to the issue of jurisdiction, so that the appeal was made in time, and there were submissions also before the full court to that effect, so that it appears in the light of that, Mr. Dattadin, in his submissions on behalf of the first and second respondents, at paragraph 24 on page 256, said, "It is submitted, the sole issue for this court is whether the case HCA 706/1999 SA was abandoned because of the inactivity of the applicant." Though it then goes on, more particularly, its failure to prosecute the matter on a timely manner as described by the High Court rules. So it would appear that Mr. Dattadin is thinking that we just need to deal with the issue of whether the contempt proceedings could amount to interlocutory proceedings, so as to prevent there being an abandonment in the light of the rules of court. So if I could just clarify with Mr. Dattadin first on this. So Mr. Jones, thank you.
Your Honour, indeed, and as usual, the court has expressed it much better than I have, but indeed that's the only issue that we see, because in the, as I understand it, in the Court of Appeal, they sent it back to the full court on the issue of jurisdiction. But they really had the right, under our rules, it's either the full court or the Court of Appeal can decide the matter of jurisdiction and should have proceeded onwards to hearing it. This matter is from the last millennium. I didn't see the value of us going back to the full court, because as my friend might be in the position that he might go back to the full court, he might be unhappy, he often is, and then he'd have to go back to the Court of Appeal again on the same issue. So I didn't think there was any value in going back. So
yes, I mean, the conduct of the Court of Appeal was rather surprising in the circumstances. So I think we shall focus, therefore, on the issue of the contempt of court proceedings and whether or not they're interlocutory proceedings, so as to prevent the abandonment period of time from arising. So, on that basis, Mr. Jones, would you like to open? That simplifies our tasks of counsel and judges, so please come forward.
So the suggestion which you have made changes the dynamic to an extent. This appeal is from the Court of Appeal. The Court of Appeal's decision is based on a single strand, which is that the full court didn't consider its jurisdiction. I think everyone in the room
knows the full court did consider its
has
jurisdiction.
immediately agreed
Yeah.
that the Court of Appeal was wrong in that regard.
Yeah.
It seems to me then that may well be the end of this appeal. The full court was wrong in its conclusion. Its conclusion was absolutely untenable. And therefore, insofar as this appeal is concerned, on the question of whether the Court of Appeal was correct in that regard, the Court of Appeal was not correct in that regard. And ordinarily, it would seem to me, the Court of Appeal now must be instructed to hear the appeal. That being said, it would be easy for me, well, it might not be so easy because I suspect I may have 5 people disagreeing, but it would be easy for me to take the position that the appeal to this court is against that very fact, which we have just solved in 3 seconds. And therefore, the proper course of action is to say to the Court of Appeal, look at the record. This was decided by the full court. The full court ruled on the merits. Here are the merits.
Yes, well, the Court of Appeal, of course, had all the powers of the full court and the high court, didn't it? So, and it had its own intrinsic powers. So the question, I suppose, is, should it have heard the abandonment point, dealing with whether the contempt of court proceedings are interlocutory or not?
Yes.
And obviously it failed to do that, but it's something that it should have done. And the CCJ, under I'm not quite sure whether it's the Act or the agreement, has all the powers of the Court of Appeal. So would that enable us to stand in the shoes of the Court of Appeal and do what the Court of Appeal ought to have done, which is sort out whether the contempt proceedings are interlocutory proceedings for the purpose of determining whether there's been a relevant period of time of abandonment?
Is that smile, Mr. Jonas, an indication that you are going to tell us that we now need to consider our jurisdiction?
Not at all, sir. And I promise you will never find me pedantic in that regard. I am happy to embrace the position of this court to cut a wide swathe and to consider the question of abandonment. You will remember I said it changes the dynamic of my argument. And therefore what I will have to do is ask Your Honours to indulge me as I change gears, because what is now being considered by this court is not the issue that the appeal was centered on. It is a wider issue. And therefore I will have to ask your permission to, just to a small extent, to go beyond what my written submissions contain, to deal both with the question of whether the contempt proceedings were interlocutory or standalone. I don't propose to spend very much time on that. But also to consider another issue, the question of how and when a matter can become abandoned if there are pending interlocutory proceedings. That has not come up, but that becomes integral to this, and I welcome the attention of the court to that particular question. But it does require me to go outside of where I started.
It may help you to know that that strand has occurred to members of the panel.
Oh no. And Persaud. Your Honours, my friend was kind enough to send to me last night. I misspoke. At 5:26 this morning, to be precise. Copies of 2 cases that he relies on. Andrews and Moore is a decision of this court that I wasn't aware of. And it solves a lot of problems for me, because this court has, in that case, looked at our unique provisions under the old rules, which I put down reluctantly after 20 years when our new rules were introduced. If I can start there, please. And forgive me, I'll regurgitate a bit of what is in Andrews, just for context. Order 32, Rule 1 of the, I'll call them the rules, please forgive that abbreviation.
Are you able to put them up on the screen?
I'm very sorry, sir. Order 32. This is the when a matter becomes very clear, Order 32 Rule 3. The right of the system. As to when this happens to go when the matter becomes very clear. So if you get enough of the way, another matter down, then you go where you went.
But sub-rule 2 is, if there are any interlocutory proceedings pending, the cause or matter shall not become ripe for hearing until the determination of such proceeding, unless the court or judge orders otherwise.
Thank you very much, sir. Precisely. Order 11 deals with the situation where the defendant doesn't appear. You file your writ, you file your statement of claim, there's no appearance by the defendant. And Order 11 says if the defendant doesn't appear at all, there is a procedure to get the ex parte judgment. That procedure involves filing a request for final judgment in what was then the bail court. So the plaintiff has to comply with Order 11, which is to file his request for final judgment in bail court, and at that point the matter becomes ripe. Order 25 deals with the situation where the defendant has appeared, but is in default of filing his defense. When the defendant does not file his defense, similarly, the plaintiff under Order 25 is empowered to file a request for final judgment and to proceed to ex parte trial. So the matter becomes ripe for hearing under Order 11, Rule 11, or under Order 25, Rule 15, upon this filing of the notice of default of defense in this case. Subject, as Justice Hayton has said, that even when you do all of these things, when you file your notice of default of defense, it still is not right once interlocutory proceedings are pending. And therefore, there are two issues to consider. First, which I hope not to spend too much time on, is whether the contempt proceedings which were filed are interlocutory proceedings within the meaning of the rules, so as to stop the matter becoming ripe. The second issue is whether, notwithstanding that the matter has not been ripe and interlocutory proceedings are pending, the matter can nevertheless become abandoned. And although those rules have been treated interchangeably because one sometimes follows the other. They are, in fact, mutually exclusive. The first deals with desertion. Your Honors, I'm aware that there's a microphone here, and I am wondering, does that affect you, or is that
Well, it doesn't.
We're hearing you perfectly
We're
well.
hearing you perfectly well.
Thank you very much, sir. Thanks, sir.
We expected no less, but we are happy to see it. Very well done.
Such collaboration from such learned friends.
Your Honor, Mr. Datadin is my very close friend out of court. In court, not so much. Rule 8 of Order 32 deals with the question of desertion. Desertion is a 6-month rule. Because a matter is deemed deserted, if no request for hearing shall be filed within 6 months after the expiration of the period fixed to the filing of such request. Now, the time frame, as was pointed out in Andrews and Moore by this court, therefore requires, once you identify your catalyst, the matter is right. You count 6 weeks, and then you count an additional 6 months for desertion.
Yeah.
Once the matter is deserted, you can't do anything more unless it's revived, an issue that does not arise before Your Honors. The mutually exclusive order dealing with abandonment sometimes flows from desertion because, of course, if a matter is deserted and a further 6 months elapses, that's the end of the matter, it's abandoned. But a matter can be abandoned without ever having been deserted, simply because the matter was never ripe for hearing, and therefore time doesn't run for the purposes of desertion. Nevertheless, time would run, the 1 year would run for abandonment as a mutually exclusive concept. So, Rule 9 provides that a cause or matter shall be deemed abandoned and incapable of being revived if prior to the filing of a request for hearing or consent to judgment, a party has failed to take any proceeding or file any document for the period of 1 year. Your Honor, the concept failure here is not insignificant. A party must have failed. So theoretically, the lovely time frames which we consistently have ignored for filing documents run. The plaintiff must file his statement of claim. The defendant must file his defense. The plaintiff must file a notice of default of defense if that defense is not filed. If the plaintiff does not file his notice of default of defense, he's failed to file a document. And it may well be that that failure may permit the matter to become abandoned, even though the matter never becomes deserted because it's never ripe for hearing. So it is my respectful view that the litmus test is whether the plaintiff has failed to file everything he can file until he's now putting his hands up and saying, I'm waiting for the court process. There's nothing more I can do, nothing more I can file, and therefore I have not failed to file anything. And because interlocutory proceedings are pending, the matter can't be abandoned, it certainly won't be deserted. To me, that is the litmus test. Now, in the case before Your Honors, the sequence of events is set out admirably by Ms. Lal, who is no longer on record. It is at page 178 of your record. The sequence is also set out in the grounds of the application before this court, at pages 2 and 3 of the record. Your Honor, out of abundant caution, I'll ask you to forgive me. I will rely on my own record at page 2 and 3, which bears my authorship. Your Honors will see that the statement of claim was filed on the 19th of August, and the notice of default was filed on the 16th of November. So the matter certainly was not deserted because it had never become ripe. And in the absence of a defense, the plaintiff did everything he could reasonably do to progress the hearing of the substantive matter by filing his notice of default of defense, saying to the defendant, "We got 2 weeks." The next document that the plaintiff could have filed was a request for hearing, but he could not file that request for hearing because the matter was not right. So there is no failure by the plaintiff to progress this matter within the language of Rule 9, as long as this court finds that the contempt proceedings were interlocutory, and therefore the matter did not become right. If the contempt motions were not standalone, the expression that is used by the full court, then that argument fails and this matter is abandoned.
Yeah.
So that is what has to be
So
decided.
if you get the date sorted out, the contempt proceedings were withdrawn on the 12th November 2001, and you then say the matter then becomes ripe for hearing, and pursuant to Order 32, Rule 1, the plaintiffs required to file a request for hearing within 6 weeks from the date of that withdrawal. So that takes us to the 24th December 2001. However, we then come to Order 32, Rule 8, is it? The cause of matter shall be deemed deserted if no request for hearing shall be filed within 6 months after the expiration of the period fixed for the filing of such request. So we have 6 months from the 24th December 2001 to the 24th June 2002, and indeed the request for hearing was actually filed on 23rd May 2002, a month before the expiry of that 6-month period. So that's your case?
Yes, please.
Right.
Could you go back and tie in with 9(1)(a)? Are you saying that therefore you never reached the stage?
Where did my assistant go?
Yes. He will return.
Mm. 9(1)(a), Your Honor, as specifically dealing with abandonment.
Yes.
Sorry, son. Thank you.
I just wanted you to tie your submissions on that into what you said about desertion.
Okay. If before the notice of default of defense, so if before the period that the plaintiff had done everything he could do in terms of filing paperwork to progress the matter toward the catalyst, the right for hearing, if a period of 1 year had at any point of time elapsed when no proceeding was taken, then I would concede the matter is abandoned. But I believe, Your Honor, that there is no period of 1 year that had elapsed at that stage.
So you say once the contempt proceedings remained on course,
Remained extant.
before they were withdrawn, then that 1A, 9(1)(a) could not take effect?
That is correct, please, Your Honor. That is my submission. Because under paragraph 2 of Rule 3, the interlocutory proceedings pending prevent the matter from being ripe for hearing. And therefore, unless there is a failure by the plaintiff to file a document, the matter is not ripe for hearing, and it cannot be abandoned. To me, abandonment relies on a failure to file a document. If you've done everything that you can possibly do, you haven't failed.
Well, it's two things in 9(1)(a). It's the date of the last proceeding had, or the filing of the last document.
Yes, please. In my view, the definition of proceeding means any step in the action. And I see that there are authorities that every time you appear in court, there is a proceeding had. For that reason, I took the point perhaps in more detail than I needed to, as to the step-by-step proceedings which were taken at first instance in the courts of the contempt proceedings, because there were many appearances in court, many adjournments ad nauseum, and therefore I believe that there was no period of 1 year under the proceeding language that Your Honor has pointed out, but also, Your Honor, under the documents filed.
Yeah, so the filing of the withdrawal proceedings comes within 9(1)(a) as a filing.
Yes, please. Sir. Now, Your Honors, on the question of whether the proceedings, the contempt proceedings, were interlocutory or standalone, I propose to rely on my submissions at page 51 of your record. Now,
could you just remind us of the page you mentioned?
51 of your record, please, sir. Now, Your Honor, to my embarrassment, when I arrived here, I observed that, for want of a nail, the kingdom may have been lost, because the legal size paper by which documents are filed at first instance, when those documents were scanned and put on this record, the bottom 1/6 of each page was lost. And therefore, when Your Honors have regard to the submissions Your Honor, I said 51, I apologize. 801, please. 801.
81.
801 of your record to 90.
Yes, page 85, you have the heading halfway down, whether the contempt proceedings were interlocutory.
Yes, please. Now, Your Honor will notice that the bottom half of that page is lost.
Well, it's not on our copies. The bottom half covers in Gilbert and Endine, a case in your favour.
Yes, please, sir.
And similarly, at the bottom of page 87, you've got the dicta of Lord Justice Nichols in the Savings Bank and Gasco number 2 case, where you have some favourable dicta.
I'm very relieved to hear that. Thank you, sir. In that case, my copy is the copy with the problem. Okay, so, Your Honors, I propose to rely on that. To me, the essential distinction is what was identified in Savings Bank and Gasco and is discussed at page 87 of the record.
Yes, so 86 to 87.
Yes, please. There are two types of orders which overlap and two types of contempt which relate to those orders. Every order of court has two characteristics. It directs someone to do something, and it is there for the administration of justice, for the sanctity of the power of the court, for the respect due to the court. Here an order directs you to do something. It has civil consequences, so that the injunction in this matter, which directed the defendants not to transfer property, had civil consequences. It was made for the purpose of ensuring that the court retained the power to do justice between the parties. And therefore, it was made on an interlocutory basis to maintain status quo, so that at the end of the day, the court could pronounce and do justice, rather than allowing the property to be dissipated and put beyond the power of the court.
Yes, so you were trying to enforce a debt, but obviously the money mightn't have been easily forthcoming, so you needed the security of the properties.
Yes, sir.
And there were some odd features of the property going from the first respondent to the second respondent, and then there being a specifically enforceable contract leading to the court transferring the property to a third person who's not part of these proceedings. But ideally, I suppose, your contempt of court procedure against the managing director of the first respondent, plus also against the two respondents, could have been designed to recover the property if they were to purge their contempt, I suppose.
Yes, please, sir. So the purpose of that order was to keep that state of affairs in play, so that the court had the property before it, between the first and the second defendants, so that it could proceed to do justice, because there was a debenture over the title of the first named defendant. Now, the second characteristic of an order of court is one which applies where criminal contempt arises. The courts, and the famous libel cases, AG and Times of England, deal with that extensively. Every order must be obeyed to preserve the respect for the court. This is necessary for administration of justice and public policy. So that with civil contempt, I injunct you from doing something, and I have to serve you with the order. And you personally are injuncted, and therefore, in civil contempt, I can proceed against you by contempt proceedings if you breach the order. Where criminal contempt is concerned, if a non-party has knowledge of the order, or if a party has knowledge of the order, even if he wasn't served, if he acts in a way that undermines the good administration of the court, undermines the due process of the court, even though he has not personally been served, he is liable in criminal contempt for undermining the administration of justice. That is the wider concept of criminal contempt. That is what came out in the AG and Time sequence of cases dealing with libel, where, Your Honor, forgive me, I suspect I am preaching to the choir, or rather the choir is preaching to the court. But the newspapers and the magazines which had knowledge of a blanket order, an order that said these issues must not be published, because they were not served, and because they were not parties to the proceedings, they took the liberty, nevertheless, of publishing the information. And it was held that criminal contempt proceedings were available against them, even though they were not parties and had not been served, because their actions undermined the purpose of the order, which was to put a blanket on the situation. That is criminal contempt. Now, in criminal contempt, the proceedings are commenced as standalone proceedings. Their purpose, and in the old days they were commenced by the Attorney General, and then later under the leave of the Attorney General, although now they can be commenced by a private person. The purpose was to punish the contemner for his criminal contempt of the court in undermining the administration of justice. That is a wide gap from civil contempt, where the person named in the order, the person who is injuncted, is the person who is liable for civil contempt. And what the courts observed, and that distinction was recognized in the Savings Banks and Casco case, was that that is the nitty-gritty of the distinction. Where there is a civil contempt, the proceeding by which you go against the contemner is an interlocutory proceeding within the action, because the purpose of that proceeding is to enable the court, to empower the court, to keep control of the property, keep control of the status quo, so that it could do justice at the end of the day when it pronounces on the substantive issues. The purpose is not to punish someone for undermining the administration of justice. So the proceedings are interlocutory, filed within the action for that purpose. Whereas with criminal contempt, there is a larger issue of administration of justice, and the court, either on its own motion or with the Attorney General as plaintiff, or by the fiat of the Attorney General, or no, a private litigant, for protection of its own administration of justice, can go against a non-party who is not served, but who is undermining the administration of justice. That is standalone. That is not a proceeding that is filed within the action so as to allow the court to do justice. Now, if the court agrees with that distinction, which is drawn in the Savings Bank case, the end result, in my respectful view, must be that when transport number 10, held by the first name defendant, was the subject matter of an injunction against the first name defendant saying you may not pass it, and the first name defendant began to pass it, and therefore transport 11 was issued, thus forming the basis of the contempt proceedings back in the 1990s. The purpose of that was entirely within the civil realm of contempt proceedings, to enable the court to keep a grip of the property which was the subject matter so that it could do justice at the end. This was not a criminal contempt. Yeah. This was a situation where a party was injuncted, that party breached, and in interlocutory proceedings filed in the action, that party was brought to task for the purpose of doing justice at the substantive hearing of the matter. If the court agrees with that, then the pronouncement in Savings Bank and Gasco is definitive. And in my respectful view, what is before this court is an interlocutory proceeding. The contempt motions were interlocutory proceedings, and therefore, Your Honor, Justice Gregory erred, and the judges of the full court erred when they found, without reference to authority, that it was standard.
Yes, you had strong support in the Savings Bank case from Lord Justice Nichols, as he then was.
Yes, please, sir. Can I go on?
Yes.
Your Honor, I always worry in this court when I am not cross-examined. That leaves me, please, Your Honors, with the question of whether there was a failure to act. And that is where I presume to go outside of the ambit of my submissions before Your Honors, and respectfully refer Your Honors to two cases from Guyana from the 1960s, which address the question which did not arise before as to the effect of interlocutory proceedings and whether those interlocutory proceedings stop a matter becoming abandoned as opposed to deserted. In LRBG 1960 LRBG, Cunningham and Lee.
Sorry, can you tell us the case again?
Cunningham and Lee, 1960 LRBG at page 69.
1960?
LRBG, Law Reports of British Guyana, at page 69.
Thank you.
What year? 1960.
1960. I'm sorry, sir.
Cunningham v. Lee. Did you
Yes,
say?
please, sir. This was a decision of the great Chief Justice Loku, as he then was in chambers. Although it's the decision of a chamber judge, I urge Your Honors not to look lightly at a decision from Chief Justice Loku. We are very proud of him in Guyana. In Cunningham and Lee, the facts were similar. Sandy, could I come out again? Sorry. Okay, 71. The facts were similar. Thanks. Page 61, Rebecca. At page 71, please.
Yeah, okay.
Now, on the facts of Cunningham and Lee, please forgive me, Your Honor, because I am taken somewhat beyond what I had originally intended to argue. I am stumbling a bit. The writ of summons in that case was filed on the 26th of November, 56. Interim injunction was granted on the same date, and the interlocutory proceedings commenced. Somehow those interlocutory proceedings became lost, so that after the writ of summons was filed, no other document was filed, so no statement of claim was filed. So you have a writ, you have proceedings in the interlocutory because the ex parte injunction was applied for, granted, the defendant appeared and began to fight the interlocutory proceedings, but they got lost. And the plaintiff failed, and please observe the significance of the word, to file his statement of claim. So he failed to progress the substantive matter during the pendency of these interlocutory proceedings. Now, on the 2nd of January 1960, the matter was set down before Chief Justice Loku for a determination of whether the matter was abandoned, notwithstanding the pendency of the interlocutory proceedings. And the learned Chief Justice made the observation: the proceedings of Order 32, Rule 32, do not prohibit pleadings in an action from being filed by the parties while interlocutory proceedings are pending. It is therefore possible for pleadings and documents to be filed even though the interlocutory proceedings are pending. It is possible that a defendant may fail to take a proceeding or file a document, even though the plaintiff may have complied with the provisions of Order 11 and Order 25, which we just referenced in the rules, relating to the notice of default. In such a case, if interlocutory proceedings are pending and more than 1 year has elapsed, there would be no default of the plaintiff, but rather the default is that of the defendant. Read literally, Order 32, Rule 9 would appear to have the effect that the cause or matter being abandoned and incapable of being revived, for the failure referred to therein is by any party, not the defendant. To avoid the consequences of that provision, it would be necessary in such circumstances for the plaintiff to apply under Rule 3 for the matter to become ripe. Now, In that case, there was a failure by the plaintiff. And on the facts of the failure by the plaintiff, the learned Chief Justice Loku said this matter is abandoned because you didn't file your notice of default of defense. Cunningham and Lee was qualified to that extent in the subsequent case of Gillette and Rye.
You're going to have to help us.
Gillette and Rye, R-A-I, which is cited at 1968, LRBG. I'm sorry, by then it was LRG, Law Reports of Guyana.
So I just repeat that.
Gillette and Rye, Gillette v. Rye, 1968, Law Reports of Guyana, at page 303. We mix it all. Now, in that case, the same facts were presented, except that the plaintiff, as in the case before Your Honor, had done everything he could do. So he had filed his statement of claim, he had filed his notice of default, and then because the interlocutory proceedings were pending, he had to wait, because there was nothing more he could do. And the learned Chancellor Stobie, giving the decision of the court, this is a court of appeal, please, of Guyana, drew that distinction in his discussion of Cunningham and Lee. And if I can refer Your Honors, please, to page 308, the decision of the Court of Appeal for Chancellor Stobie at 308. Beginning at the paragraph reference, second paragraph, reference has been made to two local cases. It is obligatory on the part of a party to proceedings to take some action, even though the interlocutory proceedings are pending. And Chancellor Stobie cites Cunningham and Lee. And the Chancellor points out that Chief Justice Loku in that case, the language which he used seemed to suggest that a default by either side could possibly lead to abandonment. But this is what the learned Chancellor then said. In my view, the decision in that case depended on its own peculiar facts. In Cunningham and Lee, the plaintiff who claimed ownership of certain immovable property sought this interlocutory order. Having applied for the interlocutory order, he refrained from filing a statement of claim. There was nothing to prevent him filing a statement of claim, because in his statement of claim, he would have had to ask for an injunction. And this is what I respectfully recommend to the court. Chancellor Stobie then says, the nature of the interlocutory proceedings did not prevent him from filing a statement of claim, and that is the point which the learned judge made, and which was the reason for his deciding that in Cunningham and Lee, the action failed under Rule 9.1, because no step had been taken in the action for over a year. The judge was pointing out that there was nothing to prevent the plaintiff filing his statement of claim, and thereby keeping the action alive. Now, at page 307, Chancellor Stobie points out that what is being considered in this appeal is whether Order 32, Rule 9.1a can apply when a plaintiff has complied with the rules, except that he failed to apply for a hearing while interlocutory proceedings were pending. With respect to Chancellor Stobie, I regret that he used the word failed. He failed to apply for a hearing while the interlocutory proceedings were pending. It cannot be a failure because the matter is not yet right. It is evident that a request for a hearing cannot be filed, as Chancellor Stobie then points out, until the cause or matter is ripe. There was no proceeding or document which the appellant, the plaintiff, could properly take or file. And therefore, in Gillette and Rye, it was held that once the plaintiff had done everything he could do to move the substantive matter forward, he had not failed to file a document or take a proceeding in the context of Order 9, once the interlocutory proceedings were pending. And therefore, the matter could not become abandoned because there had been no failure. Now, Gillette and Rye and the distinction that it drew on the facts of Cunningham and Lee also formed the basis of the decision of Justice of Appeal Chang, as he then was, in GBTI and Safi, which is cited Court of Appeal number 105 of 2001, and I have not been able to get a copy for your honors. I will send a copy to the registrar as soon as I can get it. But in that case, the learned Justice of Appeal equally pointed out that once the plaintiff has done what he can to progress the substantive matter, he has not failed, and therefore abandonment does not run once there are interlocutory proceedings pending. And if that is the case, and if your honor so find, and I know that your honors found in Andrews and Moore that this is the question of abandonment is something for the protection of the defendant that he has an option to use if there's a default by the plaintiff. So if your honors find that there has been no default, there's been no failure by the plaintiff, and if your honors find that the contempt proceedings were interlocutory by nature, so as to prevent the catalyst, to prevent the matter becoming ripe for hearing, then it is my respectful view that certainly desertion does not arise and abandonment does not arise. And therefore, this matter is alive and well. It's alive and kicking.
The last case you just mentioned with Chief Justice Chan, would you mind repeating the name of it?
GBTI, Guyana Bank for Trade and Industry Limited, versus Safi, S-A-F-F-E-E.
Thank you.
Number 105, Civil Appeal of 2001. On the facts of Safi, Your Honor, I regret it's not before you. I have had to take the liberty of going outside of the four corners of my submissions. But on the facts of Safi, a special endorsed writ was filed, and the marshal's fees were paid, and the marshal never served it. A year elapsed. And Justice Chang found that under our rules, the onus is on the marshal, having been paid his fees, to go and serve this thing and to file his return that he either served it or was not able to serve it. The plaintiff could do nothing further. And therefore, the plaintiff had not failed, the marshal had failed. And Justice Chang found that the matter was not abandoned, even though a year had passed since the filing of the writ.
Well, there might not have been a failure on the part of your client, as you suggest, but there clearly was a failure on the part of somebody. Somebody in the system did not do what they were supposed to do, it seems.
You mean, Your Honor, to fix the trial date?
For example, the one you just cited was the marshal not doing what he ought to have done. Is there any discussion of any kind of responsibility? And I'm taking even further away from your submissions, but just the system, it seems a little loose that these things can occur, and nothing happens to anybody.
Your Honor, my friend will be appearing before you in the next few weeks to point out that we have much larger problems than that.
Much larger illustrations of the same problem, perhaps.
I stand corrected. That is putting it much better.
Yeah.
But it's the concept of ripeness that creates the problem, I think. Anyway. Any further submissions, Mr. Jonas?
Not unless I can be of help, sir.
Well, thank you very much.
Thank you, sir. You need this one. Your Honor, I'm sorry. Please allow one last observation. My friend pointed out, he raised the peculiar contention in his submissions that because the notice of default of defense was filed, the plaintiff is somehow stopped from suggesting that the matter did not become ripe. But on the arguments in Cunningham and Lee and Gillette and Rye, it is quite clear that it's exactly the opposite. That the plaintiff has an obligation to do everything he can to move the substantive matter forward. And I am curious to hear how my friend advances his theory of estoppel.
Well, you'll have your right of reply. So, Mr. Blatterly. Yes.
Thank you very much, Your Honours. If we could just go one step back. I have outlined briefly the facts of it starting at page 252. High Court Action number 706 SA was filed on the 25th of May 1999. It appears that on the 24th, which was the day before, an application for an injunction was made. I say that to say that we all know the rule of Adenak and Black, and if you would have had your application for your injunction filed before the existence of a writ, there are consequences in what would flow. But I'll come back to that. Unusually, the writ that is filed in two parts. If we were to look at page 23 of the record, we have what is essentially, or could be commonly termed, the formal part of the writ.
But I thought earlier you were suggesting that we were just dealing with the issue of the failure to pursue the matter in a timely manner because of abandonment. You seem to be taking some earlier.
Yes, Your Honor, because if we just go briefly through it, because the issue would be this: the writ itself is not quite a writ known to us. It is filed in two parts, and it is not in compliance with anything that we have in our forms of a rule. There is one filed, which is the body of the writ, the endorsement, filed separately. But we go on a bit beyond that, because eventually when the statement of claim was filed on the 19th day of August 1999, that statement of claim too was out of time.
Mr. Datadin?
Yes.
I think the color that you seek to paint the applicants with, you have succeeded in your submission, but I don't know that it really does anything in relation to the sole issue before this court.
Guided, Your Honor. But what we were trying to really get to is the motion for contempt, which is in the record at one moment, please, Your Honor. The motion for contempt that was filed in these proceedings are at page 40 of the record. What is being sought is an order to imprison R.N. Persaud and a second order to imprison a Mr. Puran Ram, who is a director of the company. And thirdly, well, those were 1A and B. So, and then we have the issuing of a writ of attachment or a sequestration against R.N. Persaud and the said Puran Ram. It appears that R.N. Persaud and Puran Ram were directors of the first company, R.N. Persaud. Mr. Puran Ram is a director, of the second name company, the Legwan company. Now, Your Honor, there is no equivalent, and I think that was settled in Andrews and Moore, and it was also settled in Lewis and St. Hilaire. There is no equivalent of the Order 2, the abandonment procedures which we have in the Caribbean, for a court to, if a matter has not been addressed if nothing has happened for a year, that it be abandoned, and if nothing has happened for 6 months, for it to be declared deserted. There is no equivalent. The English system fallback is the common law and the Evans and Bartlett position for dismissal for want of prosecution. It is obvious that what our system wanted to do is, instead of having to do the common law position, which was really inexcusable delay, had to be coupled with hardship for you to succeed for the dismissal for want of prosecution. But the rules provided a time period, and as long as that time period elapsed. Now, the respectful submission, Your Honor, is this. Interlocutory proceedings are understood, and even if we are to take the argument that the contempt proceedings are interlocutory proceedings as known to what the English experience is, our Order 32 is really designed that the interlocutory proceedings must relate to the core of what the trial is. It is not intended for divergent matters that may arise that require being addressed to stop the trial going on.
In Caribbean parlance, it is not intended for any all interlocutory proceeding to have that stopping effect.
That would be a fair thing. And the reason, Your Honor, is this. There is good sense that if a matter is proceeding and a core issue is being addressed at an interim stage, which will fall for determination again at the final stage, which would be the court, the trial itself, then you should not embark upon your final trial until you have finished all the preliminary, to use another word, the preliminaries. Now, I know that it's strictly the interlocutory, and what is meant by an interlocutory proceeding is understood to be something within the matter. And even if we are to take the position that contempt proceedings are within the matter, attempting to imprison or to have writs of sequestration against them doesn't interfere with you moving forward with the matter. Now, I do understand, and I appreciate that the existence of, in these particular proceedings, there is no reason that interlocutory proceedings should take several years. We can accept that. There is no reason why trials should take from one century into another. Those being, if we move those aside, the interlocutory proceeding that Order 32 specifically addresses are proceedings that relate to the core issues at hand. Now, the reason for that, if we are to go backwards, as opposed to saying that it says that if interlocutory proceedings are in existence, is in Order 32, one moment, Your Honor. In Order 32, Rule 9, which deals with abandonment, and Rule 8, which deals with desertion, we do have the situation whereby it shall be deserted if no request for hearing shall be filed within 6 months of the last proceeding in the matter. So if we look at 9A, which speaks of the abandonment provision, any party has failed to take any
9A or 9.1?
9.1A, sorry, Your Honor, 9.1A. If any party has failed to take any proceeding or file any document therein for a year of the last proceeding and the filing of the last document therein, it's really related to the proceedings that are ongoing. Now, although contempt proceedings, if you breach an order, you're entitled, as it were, to be punished immediately. You don't need to wait until the final order, the trial is complete and the evidence is taken. If a judge makes an order within a matter and you breach it, you are liable to be punished for that breach. But, Your Honor, that doesn't have anything to do with the furtherance of the proceedings themselves.
But what about purging their contempt? And obviously, in this case, where there's a money judgment being sought, you may well need to rely on the security that was provided. And it appeared the security was being passed on to other people,
But
when it shouldn't have been, so that perhaps to purge their contempt, the property would have to come back, so the security would be available, so that the proceedings would be successful.
But, Your Honor, strictly speaking, what would have happened is you would have had an order. The order is being breached. Even if what it is, if it is to be taken of the view of the contempt, then perhaps the defendants, well, the respondents, should not have been given a hearing until such time as they purge their contempt. That would be so. But, Your Honor, we have to look at the one important fact which I was getting to about the motion for contempt. The motion for contempt seeks to imprison, seeks a writ of sequestration against them. And that motion for contempt was withdrawn, presumably because the injunction having been obtained in the manner that it did. I don't know. I wasn't in the proceedings at that stage. But it would have been difficult to ascertain how a court would have been able to order the contempt if the order itself was issued before the writ, and then there would have been a challenge. Now, there's the contrary side to that, obviously, that as long as the order is made, it had to be obeyed. But for the punishment of contempt and the requirement of the things that go with contempt, it may have been difficult. But that was that contempt which proceeded over a number of hearings, or, well, a number of dates were given for that. It was withdrawn. It wasn't pursued anymore. And then the request for hearing was filed. So if what you really wanted to do was to bring the material, the assets back to the action, you somehow decided that you didn't need that anymore, you withdrew it, and you proceeded with your action. I would respectfully submit that at any stage there during that, it would have been clear or appropriate or reasonable for you to proceed without the resolution of the contempt, because in the end, you didn't resolve it and you chose to move forward. Yeah. So if you're to say that that contempt was in some manner or form directed towards the core proceedings of the matter, then you would not have withdrawn it. Or it would not have been reasonable.
We don't know the reasons for withdrawal, do we? Because obviously there had been some rather odd things going on if there was a legal charge against the property. But it appears under the Guyanese Roman Dutch system, perhaps because no notice of opposition was filed, there might have been problems. But the real difficulty you face, I think, is 9.1 does talk about the filing of the last document in the proceedings. And these interlocutory contempt proceedings were documents involved in proceedings, which arguably did go to record the proceedings relating to the security of the debt.
Well, Your Honor, there comes to the part that I was hoping to really get to. It speaks of the filing of those proceedings. So, filing a document is clearly intended within the rule. What transpired after that filing was, it is not disputed, there was no further filings in relation to that. What happened is you probably went to court and got another date, because, or from what I can tell with the, from the fly sheet, it appears that what happened is that there was a marshal who was supposed to do something. And that marshal was supposed to come to say about, presumably, he was supposed to give the evidence that the order was served. But there was no further filings. There was a notice of, there was a motion for contempt filed with the affidavit in support. And, Your Honor, at the record, we could see that there was the motion, the affidavit, the answer, affidavit of service. All of these took place a long time before any of these, the request. If we are to take only filings, then clearly the time would have elapsed. There would be no doubt about that. But, Your Honor, if we look at the same abandonment, 9.1a, and we are to consider that what we are looking at is Order 3291A, failed to take any proceeding, file any document, or from the filing of the last document. So we have a clear time as to when, the rule is clear as to when the time would be.
Just remind me of the last document date you gave us a short while
Your
ago.
Honor, the last document date that I have, it's at pages 1 and 2 as well of the record. Affidavit in answer, 24th August 1999.
But there was the filing of the withdrawal of the contempt proceedings on the 12th November 2001.
I tell a lie, Your Honor. It is the affidavit of service, because what happened was there was an affidavit in answer and an affidavit reply, and then there was subsequently an affidavit of service filed on the 19th day of October 2000. That's the last day of a filing. Now, leave to withdraw and discontinue the motion was not done by a filing. And that occurred on the 28th of May, 2001.
Sorry, I thought the withdrawal of it was the 12th November 2001.
12th November, sorry, 2001.
Right.
And that was by a...
That
not
was...
by a document, not by a filing.
No, it wasn't by a document, Your Honor. It appears that what it was is that the appellants here, the bank, simply asked the judge in court to leave to withdraw and discontinue the matter.
That would have been a proceeding?
Your Honor, the reason why we make issue about it was you are expected to be taking proceedings. So what the bank did in this particular case, you filed the contempt motion, you went along with it for a little while, you rely on it as something important that you needed to get done, and then you decided, after you had had it running for a few years, that you withdraw and discontinue it. Now, Your Honor, respectfully, if you're taking a proceeding, the proceeding must be related to the core of what you're doing. Withdrawing and discontinuing.
Using your, as it were, demarcation, that would have been a proceeding, but it was a proceeding really in the contempt proceedings and not a proceeding in, as you would have it, the substantive.
Yes,
or
indeed,
the core.
Your Honor. The core is, yes, Your Honor.
I have you clearly. Thank
yes. Now, Your Honor, again, if we could understand why Order 32 came about. In Lewis and St. Hilaire, I believe it was Justice of Appeal Satruhan Singh who went into a little bit of that it was intended to add to the Evans and Bartlett position. And that was what the Privy Council Lord Steyn said as it related to that. So there are strict rules that bind both sides. You cannot easily evade it, but you cannot simply go along and then hope to benefit from it. And indeed, in this particular case, Your Honor, the proceedings would have to be Action 706 SA. So you had to be filing documents or you had to be taking proceedings towards your claim about recovering your debt. Now, you weren't recovering your debt in imprisonment and you weren't recovering your debt withdrawing your imprisonment. Those were things that really were not connected to what you needed to do to have
What does that mean to preserve your security for the debt?
Well, Your Honor, if it was indeed important, then surely you would not have withdrawn it. you would have pursued it because it was important.
Mr. Datterton, I think you really are stretching it there a bit.
Well, Your Honor,
We don't know why it was withdrawn.
we don't know why.
So it may have been, for instance, that there was no service of the order, and it was discovered late when the marshal failed to turn up and give proof of service. And as you and I know, you cannot imprison anybody for contempt if you do not prove strictly that there was service of the order upon them, penal notice endorsed, etc., etc. So
Indeed.
leave that alone.
But Your Honor, again, it still means that Order 32, because if we're to look at Order 32, Your Honor, Order 32 is related to the entry for hearing for the matter. And it is related to the matter in which you have filed.
The core matter, as you would
The
have
core
it.
matter.
The core matter.
And it is respectfully submitted that contempt proceedings, although they could be considered interlocutory, for the purposes of Order 32, it would only be interlocutory if it related to the core issue that was before the court.
But Mr. Datterton, I think that Order 32.3.2 would give you some reason to pause, because it says that if there are any interlocutory proceedings pending, it doesn't seek to describe what those interlocutory proceedings are, as you have tried before us today, to say that it had to be related to the core of the matter. But mind you, I take your point when you look at 9.1a. I think what you say there may have some interest from the point of view that is a withdrawal of proceeding. But as to the wide brush of 3.2, I have a little difficulty with it at this stage.
Your Honor, you see, if you look at, or if we accept that the idea is that you want matters to be commenced in the normal way and proceed towards a trial, but you don't want to have a trial when matters that have to be determined by the court are being determined or are called for interim or interlocutory determinations before you get to trial, then it would not make sense to proceed to trial before you have concluded all of these outstanding matters.
But Justice Hayton, my colleague made an interesting point. Most judges in the old days would not start a case if there was a possibility that you were in contempt, because you had to purge your contempt before you were heard.
Indeed, Your Honor. That is indeed the position. But again, what it would have been in these particular proceedings would have only put the respondent in these proceedings to a disadvantage. It did not put the appellant to a disadvantage. There is no allegation that the appellant was in breach. It was the respondents who were in breach. So what the respondents were running the risk of is that the proceedings would proceed without your input, because in the old cases, if you didn't purge your contempt, you weren't given an opportunity to be heard. Didn't mean that the proceedings didn't go on. The proceedings went on. You needed, if you wanted to be heard, you needed to get your house in order.
But you remember, there was not yet a decision on it. We're looking at how to interpret, how to consider the ambit of 3.2. And you are asking us to exclude contempt proceedings because they don't relate to the core of the matter. And I have a little difficulty with taking contempt out when the rule here is as broad as it is.
Well, Your Honor, we weren't saying to take contempt out. We were saying that if the interlocutory proceedings did not deal with the core of the matter, it wouldn't stop the trial going forward. And
I think we're saying the same thing.
Yes, but what was happening here, these contempt proceedings, were not towards the core of the matter. It did not, the proceedings would have been this. The judge at the trial would have been well equipped to deal with whatever issues he was, whether they could have had the opposition they required, and whether they were entitled to a lien on the property as they alleged, and whether they were entitled to recover. These were not issues that were going to hold up the proceedings. These were matters that were entirely capable of going on to completion. Now, the issue of...
Mr. Datterton, I am quite impressed. Your learned friend in his reply admired your submissions. I think he really meant to say he was impressed, not that he admired them. I'm impressed. Leave out admire. But I am impressed with your thesis, which you have defended valiantly, and impressed that you do not seem to think you need any legal authority.
Your Honor, I apologize.
That point. Oh, you were saving it for the last? Well,
no, Your Honor. I maybe ought to have. I only sent it in the as it relates to this morning. Right. But at page 12, I believe it is, of the actual report of Lewis and St. Hilaire, right, where the court went...
Well, perhaps you could put it up if we haven't got a copy.
Yes, I could put mine up, Your Honor. In Lewis and St. Hilaire, this is in the West Indian reports, Lord Steyn was outlining that the broad approach is what is taken.
Just tell me which page you are.
So what's the reference?
Page 12 of the report. I'm not sure which one it is on Curia.
But what?
284.
What's the West Indian report citation, page number? And I'll tell you what it is on Curia.
It is one... Yes, just one moment, Your Honor. It is 146. No, 134.
130, no.
146.
The start of the report.
146.
146.
Yes.
And what year is it?
1995, 48 West Indian reports.
So we are looking at page 285 of the Curia record.
And there is a part that says the contextual scene, that heading.
I have the arguments, and then
285.
Mm-hmm. Yes, that is at page 285 of the CCJ record. Contextual scene of Order 34.
Thank you very much, Your Honor.
Okay.
It goes with, it is now necessary to set out in broad terms the matrix. With the relevant provision of the rules must be considered. It is common ground the court has an inherent power to strike out. The Burkett and James scenario, the power is discretionary and exercisable where there is delay. It goes on. In addition, the court has an inherent power to strike out cases for deliberate failure to comply with peremptory orders, and go on. There is power to strike out an action for failure to serve a statement of claim. Your Honor, in that part, what Lord Steyn was doing, or what, as I understand him to be explaining, Your Honor, is there is the dismissal, the common law powers that existed, which have been buttressed by our powers in Order 32. And what it related to, if we're to look at what the common law powers are as a position, is it relates to what's going on in the proceedings. If you don't do anything in your proceeding, and respectfully, Your Honor, my submission is that the proceeding itself is it's the matters that relate to that. So these additional powers, it's not for, as the court said, any old proceeding that you happen to have pending that will stop a trial. It must be related, or it must be in some way connected to the court dealing with it at the end. If Your Honors are, or if the view is taken that, well, the attitude was of the contempt was to somehow return property or to deal with the assets, and that was a determinative factor, then if such a thing was sought, in the contempt motion, Your Honors, I would say these are the things that would be related. But you were simply, the appellant in this case, he was simply getting his pound of flesh. He was moving on. It didn't matter whether or not these gentlemen had been imprisoned. If the court found them guilty of contempt and imprisoned them, it wasn't going to stop the proceedings. There were companies. The companies had to continue going. The directors may suffer consequences because of what orders might have been made. And they might have found themselves in the position, the company that is, of being excluded from the proceedings until they purge their contempt. But, Your Honor, the process going forward, Your Honor, was not hindered. The proceeding could not be so wide as to be anything that went on. It must be connected to the determination of the core principles.
Sorry, Counsel, I thought that you were citing Lord Steyn at page 285, and I'm surprised that you didn't continue to read. But he was given the contextual complaint of Order 34. He's saying that you have the striking out discretion to deal with the problem, and then he goes on at the next paragraph, but you didn't read that, because I'd like to hear you expand on that paragraph.
Your Honor, as it relates to the battery of discretionary powers, insufficient to combat?
Yeah, but it is plain, yes.
Yeah, Your Honor, the part goes that it is plain the legislature considered that this battery of discretionary powers were insufficient to combat mischief of delays in civil litigation. The calculation is understandable since, apart perhaps from striking out for deliberate disobedience of court orders, the need to prove prejudice has caused great practical difficulties in striking out cases for want of prosecution. The legislature accordingly enacted the special provisions of Order 34, Rule 11, which is equivalent to our 32.9. So, Your Honor, that indeed was what we were submitting to the court. What I was submitting to the court is that in England, the power to strike out if you fail to take a step or a proceeding, or if you are delinquent, dilatory in prosecuting your claim, you can make an application to a judge. We had additional powers inserted into the Caribbean jurisdictions that I've looked at. They all have something, maybe not worded in the same way, but it's identical, at least under the old rules. They all had these identical things of abandonment and varying periods.
Yeah. It's noticeable actually as well, if you look at Lord Steyn, page 285, where he's dealing with Order 35, Rule 3.1, and goes over to page 286.
Yes, Your Honor.
He doesn't actually mention a Rule 3.2. And remember, the Rule 3.2 is the one that states, if there are any interlocutory proceedings pending, the cause or matter shall not become ripe for hearing until the determination of such proceedings, unless the court or a judge otherwise orders. So either that provision didn't exist, or Lord Steyn, for some reason, didn't omit that crucial provision, or did omit it. You see, and you go on to page 286, he doesn't deal with that key provision, Rule 3.2, he just deals with Rule 3.1, and then goes straight on to Rule 7. And that Rule 3.2 is an important one. Anyway, we can't put ourselves in Lord Steyn's shoes.
But I agree, Your Honor, that Rule 3.2 is essential because it says that the proceedings, as long as they were interlocutory proceedings pending, the matter couldn't become ripe for hearing. But the submission is that relates to a simpler, a more direct attachment to the proceedings that were going on, that was being conducted. And in these particular proceedings, given the contempt that was filed, it did not interrupt it. Your Honor, those are in essence the submissions. I know.
As usual, they were very helpful, Mr. Datterton, so thank you.
Your Honor, before I leave, I should say thank you to the newest edition, at least as far as I've been appearing in the court. And when a simple chevening scholar was trying to find a topic, he managed to find the topic of the law relating to receivers. And there was a very helpful textbook that, because we're recording, I wouldn't say how much of it I took down. But I am eternally grateful.
Thank you, Mr. Dan.
Thank you very much, Your Honor.
So, Mr. Jonas. Oh yes. Before you reply, my great apologies, obviously, with the problem we don't have everyone present in court. But Mr. Nigel Hawke, have you any submissions you would like to make at this stage?
No, please, Your Honor. We will abide by whatever audits Honorable Court makes.
Right, thank you very much. Right, so Mr. Jonas, now your reply.
If any.
Your admonition is well received, Justice Barrow. It will be very brief. Justices Barrow and Rajnath Lee made 2 points that I very briefly wish to expand on. The point was well made in Rule 9, that Rule 9 speaks to a matter where now, as we know, Parliament does not indulge in verbiage, so we have to construe those separately. A proceeding is not a document is not a proceeding. My friend has been trying to constrict us to documents until he was prompted by the court.
But you accept that there was no document filed for the withdrawal. It just arose when the contempt of court proceedings presumably were called on, and in court, counsel asked for withdrawal. Is that right? So there's no formal filed document.
Your Honor, I can't answer that immediately. For my purposes, if the proceedings were treated as interlocutory, I don't believe it was of great moment. Because if the proceedings were treated as interlocutory, the fact that the notice of default of defense had been filed in compliance with Order 25, so that the plaintiff had done all that he could do, it meant that the plaintiff had to wait for the end of the interlocutory proceedings until he could file his request for hearing, so that abandonment did not kick in because there was no failure. My friend made an interesting point introducing the word core, and Justice Barrow helped him by saying any old interlocutory action. I'm grateful for that intervention, because subparagraph 2, as Justice Rajnath Lee pointed out, does not say if there are any core interlocutory proceedings or any old interlocutory proceedings. It just says if there are any interlocutory proceedings. Now, I believe that that then raises the question, and this is where we go to core, because I think that my friend's submission is not entirely off base, but I think that where he draws the dividing line might be mistaken. the dividing line is drawn in Savings Bank and Gasco. What are core proceedings, to use his word, and I will go down that road, although I think that it's a mislabel. Interlocutory proceedings are there to enable the court to do justice between the parties in the substantive matter. There's nothing more core than that. So that if the dispute is as to a property on which there is a debenture, and somebody is trying to put the property beyond the reach of the court, it can only be core to the central issues that the court stops this from happening while it decides if there's a debenture and if the plaintiff is entitled to his damages and is entitled to proceed to a point to receive under the debenture. There's nothing more core than that. And as my friend spoke, I was trying to conceive what interlocutory proceedings would fall outside of the parameters of core to the court. And with great respect, to me the only proceedings which would not be core would be criminal contempt proceedings, where the administration of justice is involved. And under our system, those are not filed within the action. Those are not interlocutory. Those are brought by the Attorney General or by the fiat of the Attorney General, or in modern days, are brought by a private litigant. But they are originating proceedings by themselves. They are not filed within an action. So the purpose of this order was to permit the court to do justice. All the interlocutory proceedings, including the contempt motion, were core. Even if we introduce that word, it doesn't exist in subparagraph 2.
So you're saying there's no distinction between core proceedings and not sufficiently core proceedings?
No, please, sir. The distinction is a Savings Bank and Gasco. If the purpose of the order is civil, to injunct the litigant pending the trial so the justice can be done, that is central to the proceedings.
Sorry, but Mr. Jonas, doesn't the very case which was raised by counsel, Lewis and St. Hilaire, doesn't Lord Stein advocate a broader interpretation of Order 32 than he is arguing? I think that when one reads the judgment of Lord Stein, he is, I think, against the kind of restricted interpretation which counsel is arguing for, and which would sort of restrict us to core, and is suggesting that the interpretation of the rule of the order should be a broader interpretation.
A point which you made with admirable delicacy at the time, sir. And as Justice Hayton pointed out, Lord Stein did not refer to the interlocutory question in subparagraph 2. We don't know if that was before him, if he had regard to it, or if it existed in the jurisdiction in which that appeal was brought. But to me, that also is a fundamental distinction. There is one point for completeness that I wish finally to make, please. I pointed out the distinction, and Justice Barrow, I say this because of your observation, correctly, respectfully, saying that with civil contempt, before you proceed in contempt proceedings, you have to show a penal notice, personal service of the order, personal service of the motion for contempt, and that kind of thing, as in contradistinction to criminal contempt, where a contemner may be liable just because he had knowledge, even though he was not served. Now, in this case, Your Honours will observe, my friend didn't raise it, but I'm obligated to raise it, that in the contempt proceedings, one of the parties sought to be punished was a director of the company, so a non-party. But specific provision is made for that. In the civil proceedings, by Order 36, Rule 34, which provide that any judgment of order against the corporation willfully disobeyed may by leave of the court or a judge be enforced by sequestration against the company or by attachment against the director or officers. So this is an expansion of the concept of civil contempt, that the court, of course, does not countenance not piercing the veil where directors happily breach court orders and civil contempt. So the courts, under our rules, had extended it that where there is a civil contempt, as in this case, you can go against the directors even though they're not a party. But that does not bring this within the category of criminal contempt.
Yeah, actually, in the contempt order, I think it was against the directors of each of the two companies.
Yes, please, sir. Now, traditionally, if we go back 150 years, the it may be a temptation to suggest that that brought it within the realm of criminal contempt, because the director, of course, is not a party. But I raise this because this is a specific statutory expansion of the concept of criminal contempt and the people liable as contemners, that directors can be attached where there is a civil contempt. That does not bring the contempt proceedings within the realm of criminal contempt. It remains a civil contempt within the definition of Savings Bank in Glasgow, and therefore remains interlocutory proceedings which prevent the matter from being right, so that the catalyst did not drop and a request for hearing could not be filed.
Just one thing I wanted to raise other than that, because you carried me down memory lane when I was still a young attorney, felt fairly young. But in 1993, there was an attempt in the judiciary of Trinidad and Tobago to get all those inactive matters taken out of the list because the backlog was pretty bad. And there was the Supreme Court of Judicatory Amendment Rules 1993. Order 3 was amended, not in the same terms as your Order 32, but the idea was the same, which if there were inactive matters that had not been set down, and you had not taken a step or filed anything, you had not tried to proceed with your claim or counterclaim, and it stood inactive for a year, the matter could be struck out. So I just wondered if either you or Mr. Datterton had looked at that, because as I say, down memory lane, I believe there were some very interesting cases that came out of the Court of Appeal of Trinidad and Tobago. Perhaps even Chief Justice Elabastide when he went there in the 1990s at some stage. It just, I'm not sure right now, but I just wondered whether
That's very interesting.
either of you looked at it.
Speaking for myself, I did not, Your Honor. My friend
As I
says he
said, it
did
may
not.
not be helpful because the language is completely different.
Can I ask, Your Honor, was that treated as having retroactive effect?
Well, a lot of matters like that issue arose. A lot of...
But was the legislation, when passed, did it have effect in terms of default already taking place?
All of those
Oh
things.
my.
I think our Mr. Hardiel was there at the time, and you will recall that it was a big deal. Yes.
That's interesting.
As I say, I don't want to raise it to delay the matter, because there may not be anything that helps us. But I was interested in under 9(1)(e) that you had to take a proceeding. And as if people were saying, you couldn't withdraw and say that was you were taking a proceeding. It just is familiar. I hope not to cause any delay by reason.
I think a step in a proceeding, Your Honor, has to be treated as every appearance in court, especially given that on the language of the Rule 9, it is in contradistinction to a document filed, or else we would have
thesis
difficulty.
would be that a step in a proceeding cannot depend on what, when you are in court, you do. In other words, you can, on a contempt motion, on a particular day, advocate for the imprisonment of somebody, or you can advocate for the withdrawal of the proceeding.
Thank you, Justice Barrow. And may I say further that you can file an application, or you can file a notice of withdrawal, which is a document filed.
Yeah.
So certainly if the equivalent of appearing in court to withdraw or file is treated less.
Okay.
Thank you, sir.
Right, well, before you finish, let's just think about what the two possible orders are. If your views prevail, then I suppose we remit the case back to the High Court to hear it. If, however, your case fails, then what do we do? Or perhaps Mr. Datterton might be thinking more about that.
If this is not interlocutory, sir, if the contempt proceedings are not interlocutory, then the matter is abandoned.
And yeah.
It's at an end, it's over. That's an automatic effect.
Right. Okay.
And I have to buy my friend a drink, which I hope does not happen.
I think you still owe him one, so you should still buy it.
Right.
What is that?
Well, we'll adjourn for a short time, probably 10 minutes, I think.
All rise.
Judges of the Guyana Court of Justice.
Please take your seats.
One preliminary matter before we say anything further is that we ought to deal with the possibilities where costs are concerned. Would both parties be happy where costs are concerned with basic costs to be awarded to the successful party as opposed to be costs to be taxed if not agreed?
Yes, sir.
Right. Thank you very much indeed. Well, we had the advantage, of course, of reading the papers thoroughly before the hearing today, and therefore having the benefit of full argument. And in the light of the further hearing today, we've decided that we will make an order allowing the appeal and setting aside the order of the Court of Appeal and remitting the action back to the High Court for the substantive action to be heard now, because we have held it has not been abandoned. And it would follow from that, I think, that the order for costs in the court below should be in favour of the appellant, and costs in this court on the level of basic costs. However, we'll give our written reasons at a later date, but we hope that the case will be remitted and dealt with some expedition. And that's why we have decided to give the order today rather than wait a short time for the written reasons to be provided. Unless anyone, and as far as, of course, the Registrar of Deeds is concerned, we're making no order as to costs there.
Obliged.
So unless anyone has further comments, we leave it there, and the judgment will be delivered online in due course, and of course you'll be given full notice of that. Thank you.
Thank you very much, Your Honor. All of Guyana has waited with bated breath for this meeting.
Yeah. It's also set aside. Yes, I agree. So the judgment of the full court and the Court of Appeal will be set aside. Thank you.
All right.
All rise.